Welcome, everyone. My name is Glenn Cohen. I am a professor at Harvard Law School, a deputy dean here, and also the faculty director for the Petrie-Flom Center, one of your two hosts today. And it's my pleasure just to welcome you very briefly. You know, this is a co-production of Harvard and Yale. When I reflect upon it, it takes something really extraordinary sometimes to bring the world together and get people to rethink their boxes, their categories, and the way they interact. And to me, this is the smallest example of the way COVID has reshuffled the deck. We've always had very cordial relationships. We haven't done a lot of joint programming, so we're incredibly excited to be able to do this. I think we wish it was a different reason to come together, one where we could be joyously dancing around outdoors, but we are happy to marshal an incredible set of expertise and an incredible set of speakers over the next several weeks to discuss COVID, how we're doing, topics like equity and racial justice, topics like vaccine, and the like. If you first time you've encountered one of our centers, I want to encourage you to look us up on the web and to consider signing up for our newsletter, since we do a huge number of productions at each center on these topics. They're always freely available to the public. With that, I'm going to introduce two people, both of whom are my former students, which makes me extremely proud. One is the executive director of Yale's Solomon Center, and one is the executive director of Harvard's Petrie-Flom Center. But I'm going to mention one person who's not here, which is Abby Gluck, a professor at Yale Law School, my co-faculty pilot on this. And Abby's not here for a very good reason. The administration had the great sense of appointing her as special counsel to the president on COVID. So she's still with us in spirit. She's still with us as an inspiration. But we're going to soldier on without her because the country needs her. So with that, I'm going to introduce the first of the two people you're going to hear from, who's Katie Crashell, who's the executive director of the Solomon Center.
Hi, everyone. I just want to echo a lot of what Glenn said. Thank you for your warm welcome, Glenn. It is a full circle moment. As someone who is a student fellow at the Petrie-Flom Center, it's a great personal pleasure to get to join forces. We're absolutely delighted and so thankful for the partnership with the Petrie-Flom Center on such an important topic. I remember when I pitched it to, or Abby and I were discussing the idea, I said, you know, I know it's like bringing together the Yankees and the Red Sox sort of, but let's do it. And there was no pushback. So we're so thrilled to be able to marshal the expertise of both of our centers and to bring together really great contributors for this panel series that we hope you'll join us for in the next few weeks.
So I was going to actually introduce you, Mel. I will introduce you, Carmel, because there's a pause. Carmel Shachar, the executive director of the Petrie-Flom Center.
Thanks, Glenn. So I will serve as your flight attendant, so to speak, walking you through the logistics of the event. We have 4 fantastic speakers who I will introduce in a moment. Each of them will present, and then at the end of the event, we will have a question and answer period. We welcome your questions. We hope that you have a lot of questions for our presenters. You might ask, how do I submit those questions? There are 2 ways to do it. The first and best way is to use the Zoom Q&A feature. And if you go down to the bottom of your Zoom screen, you'll see a box that says Q&A. When you submit that question, the panelists will be able to see it, and we are monitoring that stream. You can also join the conversation on Twitter using the hashtag #COVIDLawPolicy. Again, that's hashtag #COVIDLawPolicy. Center staff are monitoring that hashtag, and if you have a question there, they will pull it and they will submit it to the Zoom Q&A feed. Ways that you cannot submit a question, please do not use the raise your hand feature. It's really cute, but we will not be monitoring that, as well as do not use the chat. It won't be monitored. With that, I would like to warmly welcome our panelists for the first of our seminar series. Presenting first will be Wendy Parmit, Matthews Distinguished University Professor of Law and Director, Center for Health Policy and Law, and Professor of Public Policy and Urban Affairs at Northeastern School of Public Policy and Urban Affairs. Rakaya Yerby, Center for Health Law Studies, William C. Wessel Center for Employment Law, School of Law Professor, and Executive Director and Co-founder, Institute for Healing, Justice, and Equity at St. Louis University. Then we have Nicole Huberfield, Professor of Health Law, Ethics, and Human Rights, BU School of Public Health, and Professor of Law at BU School of Law. And last, but certainly not least, is Lindsay Wiley, Professor of Law and Director, Health Law and Policy Program, American University, Washington College of Law. With that, I don't want to put too much time between us and the substantive order of the day, so I'd like to hand the Zoom over to Wendy, who will start our presentation.
Wendy, you're
Wendy,
muted.
I think you are still on mute.
So sorry. Thank you so much. I apologize. I just wanted to thank Glenn, Katie, Carmel, and everybody at the Solomon Center and Petrie-Flom for inviting me to participate in this amazing event. And it's such an honor to be here with this all-star panel. The paper I'm going to present is less about the legacy of COVID on evolving doctrine and more really about the legacy of evolving doctrine on our response to COVID-19. This is part of a project that I've worked with my colleague, Jeremy Paul, for a little over a year, but this is our first opportunity to present the paper. It's very much a draft, and I really look forward to all of your comments, which I'm sure will help improve it. So very early in the pandemic, the World Health Organization warned against what it called an infodemic, the proliferation of false and misleading information about pretty much everything related to the pandemic. The infodemic has undoubtedly undermined public health efforts to contain the pandemic and now threatens to interfere with vaccination campaigns as misinformation has undermined trust in vaccines. Of course, misinformation about plagues and vaccines is not new, but the current infodemic, we believe, goes well beyond familiar forms of vaccine rejection or even science skepticism. Contemporary conditions have produced a more virulent form of skepticism that questions whether meaningful truth can be or need be found at all. In effect, the infodemic about COVID has merged with what has aptly been called the post-truth phenomena. In our paper, we seek to identify the key attributes of this phenomena and focus on the ways in which health law has inadvertently enabled an environment in which the post-truth can take place in relation to health. What is post-truth and how is it different from critical thinking or healthy skepticism? We identify three key related attributes. First, there is a loss of confidence that a productive exchange of views, informed by guidance from experts, can generate effective solutions. Second, there's an abandonment of learning in favor of affiliation-based choices. And third, a high comfort level with the idea that there is no such thing as a fact. In effect, individuals no longer seek to determine whether something is true, nor do they evaluate policy based on the underlying facts. Instead, they reach decisions and form judgments about masks, vaccines, medications, based on what their friends think and what their gut tells them. Importantly, cognitive biases, including the confirmation bias and the Dunning-Kruger effect, amplify this. We accept what we already believe is true, and the less we know, the more sure we are that we are right. In this environment, the discourse and debate that is needed for a democratic polity to respond to a public health crisis, as well as the trust that is needed, are lost. Well, what are the roots of post-truth? Scholars have identified many causes of post-truth. Political polarization, accentuated by partisan media outlets, a president who indulged prolifically in lying, the rise of social media, loss of faith in institutions, increasing inequality, and many more. we don't question or go through all of these factors. Our contribution is the addition of health law and bioethics to the list. We do not say they are the most important factors, but they are the ones in our own lane that we can and should consider. Above all, our aim is to persuade health law scholars that if we cannot come to grips with the dangers of post-truth in relation to health, all of our bioethical and public health advances will remain in peril. Importantly, the health law roots of post-truth began and continue as a needed correction to the abuses of human rights and individual dignity that have been perpetuated by medical authority for ages. Indeed, the early recognition of autonomy and informed consent, which you shall see we relate to post-truth, dates back to the Nuremberg Declaration and its insistence in response to the atrocities of the Nazi doctors that informed consent was the first principle for ethical human subject research. In the US law, informed consent and distrust of medical authority is often traced back to the Tuskegee syphilis study, which led directly to the Belmont Report and eventually the Common Rule, which codified informed consent as a key principle for human subject research. Informed consent, however, does not only apply to human subject research. In the 1970s, courts began to hold that physicians had a duty to provide patients with the information that reasonable patients would find material prior to making treatment decisions. In doing so, cases such as Cobbs versus Grant and Canterbury versus Spence emphasize patient self-determination. They also express the view that patients need to be informed by experts, their physicians, in order to realize their own self-determination. Back then in the 1970s, informed consent did not imply a subjective determination of facts, only of preferences and values. Still, informed consent has often been viewed as a key step in the dismantling of medical authority and the law's endorsement of patient decision-making. In later cases, in the 1980s, starting with Henry Quinlan, courts moved beyond requiring physicians to provide information to patients to recognizing that patients or their surrogates had the right to choose life-sustaining treatment. In Cruzan, for example, the Supreme Court stated that, quote, the logical corollary of the doctrine of informed consent is that the patient generally possesses the right not to consent, that is, to refuse treatment. Concurring in Cruzan, Justice O'Connor went further, stating that an individual had a constitutionally protected liberty interest in refusing unwanted medical care, and that states may well be compelled to accept the decisions of duly appointed surrogates. We can also see the evolution of patient decision-making and the concomitant evaluation of medical authority in the law about abortion. In Roe, the court emphasized the decision to have an abortion was one that a woman could make in conjunction with her physician. In 1973, abortion law affirmed medical authority as much as the rights of patients. But by the time of Casey, the court had come around to recognize this right as the woman's. Yet even in later cases, courts have accepted restrictions on patients' access to abortion that rest on scientific rationales that are not supported by scientific consensus, in effect, by pseudoscience. And abortion jurisprudence has come in many ways to resemble a battle between the claims of patient autonomy and the claims of pseudoscience. To be sure, the Supreme Court in Whole Women's Health struck Texas's regulation of abortion clinics largely based on the fact that the state's claims were not supported by medical evidence. Whether this reliance on expertise will persist after Justice Barrett's ascension to the court is questionable. But in any case, by relying on scientific claims that are wholly unsupported by the evidence, abortion opponents have helped, however unwittingly, to topple medical authority. For our purposes, it's important not to focus too much on abortion. The broader women's health movement of the late 20th century sought to challenge medical patriarchy, emphasizing that a woman should be educated about their health and free to make health-related decisions on their own. This movement helped to push for direct-to-consumer drug warnings, first for contraceptives and then estrogen replacement. All of these changes, most of which were positive in many ways, helped to dismantle the gatekeeping and information providing functions of healthcare providers. In effect, not only was the medical profession's authority to make decisions challenged, so now was challenged its role as mediator and translator of medical information. Indeed, the very idea of our bodies ourselves, the foundational book of the women's health movement, was that women, and eventually everyone, need not and should not rely on experts to learn about their own health. We can all become health experts. We also discuss in the paper the important role of AIDS activism. Responding to the government's neglect of the epidemic, activists mounted in the 1980s a powerful campaign to push for a greater role for patients and activists in setting the agenda for biomedical research and deciding when investigational drugs should be made available to patients. Their movement led to important changes to NIH and FDA policies, some of which were codified, that helped to fast-track drug development and lead to expanded use of compassionate use policies. As we show in our paper, many other patient advocacy groups followed suit, pushing for greater deregulation by FDA. These efforts also helped to loosen regulation of dietary and nutritional supplements, and again supported the view that patients, rather than physicians or regulatory agencies, should make decisions. Without questions, these movements have done much good, but they have also eroded the FDA's role not only over drug approval, but over the creation and dissemination of scientific information. Direct-to-consumer advertising, spurred by the Supreme Court's increasing protection for commercial speech, has further cabined the FDA, while also allowing patients to sidestep physicians. More recently, the Supreme Court's diminution of the Zadora rational basis review for compelled speech has thrown into doubt regulators' ability to compel even truthful health-related information in advertising, and potentially and dangerously along the provision of vaccines or other treatments. In short, in today's world, patients learn about diseases, prevention, and treatment through advertising and social media platforms, and then take that information to their physicians, or even to the physicians who the drug companies happily make available to them. This has many advantages. It may help patients get medications they need, but it acclimates us to a world in which we make medical decisions without dialoguing with our physicians, or without them providing us the information that the law of informed consent, originally envisioned. Shortened medical visits pushed by billing pressures have magnified this development. Today's patients are faced with more choices and less access to experts. In effect, patients are expected to make a plethora of decisions related to their own health, unencumbered by expertise. All of that was before the pandemic. So what does this have to do with the post-truth pandemic? By prioritizing individual choice and denigrating paternalism, health law has helped to erode trust in expertise, but it hasn't stopped at fostering healthy, if contentious, dialogue between patients and experts. It has also undermined regulatory agencies such as FDA and CDC that once served to educate the public about health-related matters, while weakening, again in the name of patient choice and empowerment, the provider-patient relationship. We write in the paper, quote, "The culture of patient choice and personal responsibility has taught individuals that they are as competent as experts to decide whether masks reduce the transmission of COVID-19, whether COVID-19 is more dangerous than the seasonal flu, or whether vaccines work. The mantra of patient empowerment that the law has embraced and facilitated gives little weight to verification, falsification, replication, or the benefit of years of study. Gut feelings and preferences, abetted by affiliation, affinity, and the persuasive power of advertising, are given equal, if not greater, credence than peer-reviewed papers or expert panels. Thus, the autonomy of choice morphs into epistemological subjectivity and post-truth. In writing this, we don't mean to suggest that health law and bioethics are solely or primarily responsible for the post-truth world. Indeed, we believe that the transformation of health law that we have described is as much symptom as cause. Yet this is an important moment, we argue, for health law scholars to consider how our field may have, for the best of reasons, nurtured the seeds of post-truth. As COVID-19 and the climate crisis remind us, nature is not bemused by our subjectivity, nor does it respect atomistic autonomy. If we are to prevent future health crises, indeed, if we are to be truly informed, as informed consent's goal originally sought us to be, then we must find a way to privilege skepticism without inviting nihilism. Thank you.
Thank you, and I will start. So today I am going to discuss eradicating pandemic health inequities and using the health justice framework to get us there. So I'm going to be highlighting two main points. During the COVID-19 pandemic, it became clear that the social determinants of health are central to pandemic health inequities. And so what do I mean by health inequities? I mean health differences that arise from discrimination or marginalization, likely to reinforce social disadvantage and vulnerability. And we've seen this particularly in two ways. One, that it increases a population group's exposure to COVID-19, and two, that it limits the population group's ability to comply with social distancing measures. And I'm going to talk about the social determinants of health, the historical ones, and then also the updates that were made in 2019 and recently were just published as under Healthy People Initiative 2030. My roadmap: I am going to talk further about the social determinants of health, show how they actually have led to increased rates of exposure to COVID-19, discuss the emergency preparedness laws, and give you a specific example of essential workers and provide solutions. So as I mentioned, the social determinants of health were first added to the Healthy People Initiative in 2010, and most recently it has been updated in 2030 and includes economic stability, and that is what I'm going to be focusing on for today, which includes work and employment factors that include compensation, benefits, and health and safety protections. What is key that I want to highlight, which is not on this slide, is that the U.S. Department of Health and Human Services is in charge of overseeing the Healthy People Initiative, as well as the social determinants of health. The Public Health Services Act provides this authority, and it is used to provide measures and guidelines that are followed by the state to try to attain health equity. In the revisions, we see for the Healthy People Initiative on 2030, the Centers for Disease Control and Prevention, which is an agency within HHS, was one of the lead federal agencies in the Social Determinants of Health work group, as well as the Occupational Safety and Health group. This will become clear why this is relevant a little bit later, but let me just say the key is really that the people who are doing the work and leading the work on the social determinants of health are also the same people who are leading the charge in terms terms of our federal response to emergency preparedness and COVID-19, but yet these two functions are left separate, which is to increase people's exposure to COVID-19 as well as limited their ability to comply. I want to highlight one of the key objectives of the Occupational Safety and Health Work Group was to reduce deaths from work-related injuries that should be used to measure the attainment of health equity. So how have the social determinants of health impacted or increased infections during COVID-19? We see research showing that between 6 to 8% of all US COVID cases in the United States are tied to meat and poultry plants. But I just want to highlight that that's not just for the workers. Research also shows that having a meat and poultry processing plant in a county is associated with a 51 to 75% increase in COVID-19 cases and 37 to 50% increases in deaths of all the people in the county. This is important because, as was shown in the prior slide, the social determinants of health work increases exposure to COVID-19. And I'm going to talk about that a little bit more. We see that COVID-19 exposure in the workplace is key, not just in meat and poultry processing workers, but also farm workers. In one workplace, 150 employees of a pistachio farm in California and 65 members of family members tested positive for COVID-19. And in Boston, data shows that the highest number of COVID-19 cases are concentrated in communities with a very high proportion of both essential workers and racial and ethnic minorities. So when we think about emergency preparedness during COVID-19, a majority of the measures being used have been social distancing orders. I'm going to focus on one particular one, the stay-at-home or lockdown orders. We also see mask orders, but I'm not going to address those, but know that those are also connected to issues around workplace and workplace spread. When we look at a majority of the social distancing orders, they're based in large part on the CDC, which was the first federal agency in 2004 to begin using the term social distancing. It has changed much since then, but during COVID, we see many places, including where I live, St. Louis County, issuing stay-at-home orders, trying to ensure that people socially distance and to prevent, mitigate, and contain the spread of COVID-19. But there's a disconnect because many of these stay-at-home or lockdown orders do not address the lived experiences of workers. And so in the St. Louis County stay-at-home order, they mentioned that essential businesses were strongly encouraged to stay open, but did not discuss any ways for those workers to socially distance when they were at work. States have taken the primary lead in adopting many of these emergency preparedness laws, plans during COVID-19, but CDC has played a role, and HHS and CDC do have powers to address emergencies. Many of us know that the CDC has issued guidelines on how to treat people. Either if you come into contact with an infected person, you're supposed to stay at home for 14 days. If you are infected yourself, you're supposed to stay at home for 10 days after your first symptoms appeared, and there are other measures. But note the difference that here we're saying that people should stay at home, but in its guidance, in its workplace guidance with the Department of Labor, it simply said that employers should consider modifying their sick leave policy so that ill workers could stay at home. And so I'm going to talk about this a little bit more, but we can see that the difference treating people who are essential workers or workers differently than the general public does not allow you to prevent, mitigate, or contain the spread. The disease does not care if you're an essential worker and working outside the house. And so the failure to actually implement the same guidelines on staying at home for employees increases the risk of the spread of the disease. We can see this definitely in the example of essential workers. I'm going to highlight two particular groups that make up over 50% of essential workers. So about 30% of essential workers are employed in healthcare, majority are women, a majority who are in frontline jobs, nursing, personal care aides, home health aides who work at nursing homes, are racial and ethnic minorities. 21% of essential workers are employed in food and agricultural, and a majority of them are foreign-born, Latino. And these numbers are really about the frontline workers, the people who are close together, not socially distancing. So what is the harm? So we see high rates of infection among these workers. So almost 500,000 meat and poultry processing workers, almost 57,000 of them have been infected, and at least 277 have died. And these numbers are as of yesterday. And we can see that a majority of the cases are racial and ethnic minorities. What is the problem here? One is that we have an increase in exposure because of attendance policies. Many of these meat and poultry processing plants have punitive attendance policies where people accrued points and could be fired if they had too many points, if they missed work. Unfortunately, they have continued these policies during COVID, and here at JBS, where they had a major outbreak earlier during COVID and now are experiencing a second major outbreak, they've actually decreased the amount of points that workers can accrue from missing work. Why is this a problem? Because many of these companies, JBS included and Tyson, require workers to go to work sick even if they are experiencing symptoms of COVID-19 or awaiting test results. And here you can see in this particular facility, they require a doctor's note and for you to call into English only hotline. But remember, a majority of these workers are foreign born. Lots of them do not speak English and do not have access to a doctor. One Tyson plant actually does not approve prearranged absences for testing unless it does not affect the production schedule. It also limits the ability to social distance. And so it limits the ability because many of these workers lack paid sick leave. They lack paid sick leave before COVID-19, and many of the COVID relief economic bills did not cover them that actually provided paid sick leave. Many, including the CARES Act, which did not apply to businesses with more than 500 workers. And as I showed you, that JBS facility that has had 2 outbreaks employs more than 500 workers, so it does not apply to them, and it does not apply to undocumented immigrants. Why is this a problem? Because people without paid sick leave are 1.5 times more likely to go to work and spread it. And so if we think back to the CDC guidelines that employers should consider allowing workers to stay at home, workers cannot stay at home. One, either because they're afraid that they're going to be fired, or 2, because they don't have paid sick leave. And so what do we need to do? My colleagues and I, one of them who will be speaking later, Professor Lindsay Wiley, Professor Emily Benfer, and Professor Seema Mohapatra, have been working on the health justice framework, which has 3 particular points that are relevant here. 1, structural remediation, so that's the first prong. And really here it's about changing the emergency preparedness law so it addresses and helps facilitate individuals to stay at home, which they're not able to do now. 2, provide financial supports, paid sick leave for people to stay at home. And then finally, it's about empowerment and engagement of workers. And so how will this play out specifically in this case? One, it really is about putting together the social determinants of health along with emergency preparedness laws. As I mentioned, Health and Human Services and CDC have the power to not only address the social determinants of health, but also emergency preparedness. The Public Health Services Act and many other laws give the authority to HHS to be able to address these emergencies. And we see CDC using this when they issued the eviction moratorium because they said that it would be linked to increased rates of COVID-19. That's the same for punitive attendance policies. If you force people to go to work when they are sick, when they are affected with COVID, that is going to increase the spread and exposure of COVID-19. We need paid sick leave and guaranteed basic income, and this goes to financial supports. People cannot stay at home if they do not have, if they cannot pay to eat. And finally, workers should take the lead in reforming this policy. President Biden issued a long report on trying to address COVID-19, and it included empowering communities and also using community health workers. And as we empower them, allow them to take the lead, we also need to make sure that they are receiving funding, not just the community, but the community members as well. So with my 50 seconds, I'm just going to say implementation. I haven't had a chance to mention this, but there was a 2011 HHS toolkit, which provided some evidence base for this information and actually increasing racial and ethnic minorities involvement with addressing this. And 10 years later, we need to actually use this to support the work that we're doing to eradicate pandemic health disparities. And with that, I just want to highlight the work that my colleagues and I have been doing around this, and thank you.
Good afternoon, everybody. I'm Nicole Huberfeld, and I'm really delighted to be with you today. And thanks to the good folks at Petrie-Flom and the Solomon Center for organizing us and bringing us together, even in this unusual environment. It's really rewarding to hear my colleagues on this panel, and I look forward to the other panels in this series. So today, what I'd like to talk about is COVID's legacy, of course, but also what that legacy looks like in the world where we have had to struggle with leadership failures. I think a lot of people have been pointing toward leadership failures as the #1 reason that we're struggling so much with COVID in the United States. But I think the story is much more complicated than that. So if we think back to a year ago when COVID really was first entering the United States, at this time, a year ago, the Department of Health and Human Services had just issued its first public health emergency order. And at the same time, we were still witnessing Democratic presidential primary debates. And the focus in those debates was actually health reform, if you can remember that. And many people were talking about how to modify the ACA, which had just celebrated its 10th anniversary. And some were even calling healthcare a human right. And given the path of prior disasters and given the context of the primaries and the conversations that were happening at the time, it seemed possible that some solidarity might occur in the face of an emergency like a pandemic. And that emergency, that solidarity might in fact help to drive legislative reforms or some kind of public option or Medicare for all. There were so many options on the table. The kind of universal coverage that would fulfill the promise of the Affordable Care Act, which really was designed to create near universal coverage for most people. Now, one might think that that was a silly prediction, and I would certainly take that critique. But usually in an emergency, if we think back to events like 9/11, we do experience some kind of social solidarity. However, we also know that rule of law was largely eschewed by the Trump administration, and it turns out that the pandemic was no different. Public law especially has been destabilized in ways that raise fundamental questions that we're going to need to examine to understand the legacy of COVID for years to come. And so in many ways, this is a very early conversation for us to be predicting what the legacy of COVID is. Yet, in order to understand COVID's legacy, or at least to begin to understand it, I think we need to begin to tease apart leadership failures from our structural choices in health in particular. In addition, we need to tease apart both short-term responses and long-term policy choices. Many say leadership failures were the biggest problem, but there's much more going on here. We need to take a hard look at the choice of federalism, how and why we use it in such a regular fashion as a regular feature of individual and public health in the United States. Because while divided responsibility is sometimes constitutionally necessary, it is more often a legislative or policy choice, a decision that we make to allocate responsibility to federal or state or local or tribal government. And federalism, being a regular governance feature in health laws, is one that often fosters partnerships, necessary partnerships, or at least fruitful partnerships between the federal government and the states. But it also fosters complexity, and that complexity demands careful management. If leadership is lacking, then the assumption of control for a given policy issue can fall apart. And prior state choices, regardless of leadership issues, are an important feature of any emergency that can either help or hinder emergency response, can either elevate or overcome disparities in health and economic troubles, regardless of leadership issues. So let me begin to tease apart these issues by focusing first on what happened at the federal level in the last year. So if we think about Congress's response to COVID in broad brushstrokes, it was fairly typical. The relief bills that were enacted in March of 2020 were typical for an emergency, at least in modern times. There were financial supports for individuals, for businesses, and for states. The CARES Act, for example, supplemented unemployment insurance measures that the states were trying to issue. And the Families First Act created an enhanced federal match for Medicaid, and also in a novel move made it so that there would be paid federal leave for families suffering from COVID. These laws otherwise were very much like what we saw with the ARRA in 2009. They gave financial support, some policy measures, but also very heavily relied on state partnership to take up the federal money and the federal guidance that were issued in these laws. The president declared a national emergency on March 1st of 2020, but then largely refused to use the unique emergency powers that federal law makes available to the president to respond to an emergency. And in fact, if we look beyond the exceptions of Operation Warp Speed, which of course helped to speed the vaccine effort, and international border closures, what we see is a list of how not to behave in a pandemic in many ways. The president said things like, "We're not a shipping clerk," and created competition between the federal government and the states for PPE and for other necessary supplies to respond to the pandemic. He refused to use his own coronavirus task force, and in fact often undermined what they said, confabulating bizarre treatments like sunlight and bleach for novel coronavirus, and resisting containment measures that states were issuing in the absence of federal centralized authority or guidance, making it look like it was okay to resist measures like wearing masks or keeping physical distance from other people, and therefore, of course, leading to his own COVID infection and an outbreak in the White House. I could go on and on with the list of what not to do in a pandemic, but I think the important thing here is the signaling effect that the president's actions had. There was an expressive value to these actions that made it okay to shirk state containment efforts, and that made it so that there were confusing messages both for state officials and for the public. A recent study even indicates that there's an undercount of the number of COVID-related deaths in places that are Trump-supporting locales, largely because there was less testing, but also because death attribution is a choice that is made at the moment that a coroner is filling in forms. And if that person's an elected official, then they may make a non-COVID-related choice. So there has been a black hole where federal law assumes that the president will exercise emergency powers, and where the public, in fact, expects centralized power in an emergency. As I'll get to in a moment, this created a real bind for governors in many instances. Let me just take a minute to talk too about what happened with the Department of Health and Human Services. HHS issued a public health emergency that was effective January 27th, 2020, and that PHE made it so that there were regulatory flexibilities that came into effect, as well as certain kinds of financial supports for states that shored up Medicaid and made it so that at the very moment that the enrollment was increasing, states were getting more flexibilities to both facilitate enrollment and also to support it financially. This was also enhanced by the Families First Act, which created an enhanced federal match, as well as MOE, or maintenance of effort requirements, that make it so that states have to keep people enrolled if they take that extra federal money during the emergency. So HHS too, like Congress, did take some of the standard measures that we see in an emergency. On the other hand, HHS did not encourage Medicaid expansion in the 14 states that had not expanded at the beginning of 2020. And it also didn't open a special enrollment period for novel coronavirus on the federal exchange, making it so that in 2/3 of states, if people lost their jobs, they had a very limited period in which to take up commercial insurance on an exchange. Further, HHS also kept waivers rolling in Medicaid that encourage things like work requirements and also funding limitations like block grants. These are things that create hurdles to Medicaid enrollment. And if it weren't for federal law saying if you take extra money, you cannot create hurdles to enrollment, then these too would have been rolled out in the midst of a pandemic. Federal law, like the Stafford Act, assumes state partnership in an emergency. But remember, emergencies are short-term. These short-term measures build on states' prior policy choices. In the states with stronger safety nets in position at the time that the pandemic hit, those states were in a better position to deal with the health and economic emergency created by COVID. And when any disaster occurs, for that matter, the population is more resilient and the infrastructure of the state itself is better able to take up federal aid. This variability that exists among states heightens disparities. It makes it so that in the states with strong social safety nets, people have somewhere to turn in the time of a disaster or an emergency. But in states with weak social safety nets, there were greater health and economic disparities that were worsened by the pandemic. So let's take a look at how this looked in the states, because governors were forced to fill gaps. Some used their emergency powers more, and some used emergency powers minimally. I'm just going to share my screen for a quick moment and demonstrate what this looked like. So if we consider, this is what states looked like early in the pandemic. We saw that there were gathering bans, paid sick leave, non-essential business closures, mandatory quarantine, and there was wide variability amongst states for these short-term measures. State containment measures somewhat corresponded to the severity of the outbreak within the state, and we saw that these measures were relaxed to a degree at the end of April and into the summer, but of course they ramped back up early in September when there was that post-summer spike again in many states. And what we see here is that some states were issuing quite stringent containment measures: California, Washington, New York, Massachusetts, a variety of states. At the same time, some states actually refused to exercise existing emergency authority. States like Mississippi even tried to make it so that cities that tried to issue containment efforts were hindered in their own local containment efforts. We saw the same kind of thing in states like Texas and North Dakota. And the problem here, of course, is that, as we might have intuited, the more variability or heterogeneity there was in state policies, the more we could see that these policies had the effect of increasing the severity of the outbreak in every state. So this is drawing on measures of state stringency in their containment efforts, and the daily cases in the 50 states, work that's being done over at Oxford University in conjunction with Johns Hopkins. And you can see when you look at these charts that the red indicates, and I know this is a little bit small to see, so I'll tell you, the red indicates stringency of state containment measures, and black indicates the daily cases per 100,000. And so if you take a state like Alabama, what you see is an early rise in stringency measures. And then the cases were quite low in Alabama, but then as stringency measures came down, the case rates went up, right? And you see the same pattern in every state. Somewhat infamously now, if we look at a case like North Dakota, their stringency measures always remained fairly mild, and their containment measures, excuse me, always remained fairly mild. And then of course there was an enormous spike after all of those less stringent containment measures were in place. So states had a widely variable set of short-term emergency responses, many of them coming from governors. Now governors are experiencing in this legislative session that some state legislatures are trying to limit what governors can do. But there were longer term decisions that states had made that made these short-term decisions elevated. So for example, in the paper, I note that many states had been underfunding public health in the decade and even longer before the pandemic. And in fact, many states spend much more money on policing than they do on public health. And perhaps more to the point, many states had made choices within the implementation of the Affordable Care Act that exacerbated or eased the effect of the pandemic. So for example, in states that had implemented Medicaid expansion, their safety net was stronger. Also, many states had sought waivers that made it so that enrollment was challenged for Medicaid, even in states that were non-expansion states. Further, some states decided to try, like Georgia, to undermine the federal exchange, making it more difficult to enroll in commercial insurance. And some states also supported things like short-term plans and junk insurance rather than trying to get ACA compliant insurance to be the predominant form of insurance in the state. Every state and the District of Columbia did use Medicaid's state flexibilities, using the enhanced federal match, easing enrollment, and maintaining enrollment and eligibility. But these are just bridge measures. An emergency requires competent and coordinated leadership. Federal law assumes that federal-state partnership in an emergency will occur, that federal expertise and money will flow to the states, and that the states will operationalize that expertise and that money. The legacy of COVID cannot just be a blame game of leadership. Rather, we need to understand that this phenomenon of zip code dictating health predates COVID and brings health inequities into sharp relief. Even without leadership failures, an emergency relies on state uptake of emergency measures in the short term, but also prior state policy choices, making federalism a potentially risky choice in health laws, which will have implications for Biden care going forward. Thank you.
Hello, thank you. I'm honored to be part of this important discussion, and I'm learning so much from my fellow presenters as I have all year from the fantastic work that they've been putting out. I'm going to wrap up this panel with some reflections on the potential legacy of COVID for the ongoing development of infectious disease control law and public health law writ large in the decades to come. In particular, I've been tasked with focusing on the future of Jacobson v. Massachusetts as a viable precedent for modern courts grappling with public health law disputes. This is going to be highly relevant for the coming stages of this pandemic, potentially involving questions about compulsory vaccination. It's also going to be relevant to more routine matters like school vaccination mandates for measles, pertussis, and more. And Jacobson has also been cited in a whole host of public health law decisions about things like nuisance law and various other matters that go beyond infectious disease control. So when I was asked to think about the future of Jacobson, like many of you who are teachers and students, I reflect back on my experience of teaching my last in-person class before the pandemic really hit in the United States. My last class was on March 3rd. It was a class on public health emergency response powers. I had assigned that topic months earlier. It was a total coincidence that that was what we were talking about that night. We talked about what we might expect in the US in the days and weeks ahead. We were eyeing travel restrictions, business closures, stay-at-home orders that had been implemented in China and Italy at that point, and questioning whether those kinds of orders could be implemented here in the US and how the courts might respond if they were. And we were reading Jacobson v. Massachusetts for guidance. I remember on the drive home that night thinking that I would probably never teach that class or that case the same way again. It's hard to imagine right now when we're in the midst of the peak of this pandemic and even staring down the possibility of a fourth wave that could hit in March. But eventually our attention will return to the legacy of this year for the ongoing development of public health law. And a key part of that legacy will be our evolving understanding of and uses of Jacobson. Jacobson is a 1905 Supreme Court case. If you had not heard of it before 2020, you're not alone. It's rarely covered in constitutional law classes, but it's the bedrock of any course in public health law. It was decided a few years after a major outbreak of smallpox in Boston and the Boston area from about 1901 to 1903 that resulted in about 1,500 cases and about 300 deaths. The outbreak reignited a long-standing debate over vaccination for smallpox. At the turn of the 20th century, anti-vaxxers of the day claimed that compulsory vaccination was the greatest crime of the age, that it slaughtered tens of thousands of innocent children, that it was more important than the slavery question because of its debilitating effects on the entire human race. Sound familiar? In the midst of this debate, Massachusetts enacted a law empowering local health boards to require vaccination of all inhabitants if the Board of Health deemed it necessary for the public's health. And that was really the only guidance from the legislature in terms of a substantive standard. The Cambridge Board of Health, under the statute's authority, adopted a regulation ordering all inhabitants of the city to be vaccinated. Jacobson, who refused, was convicted by a trial court and sentenced to pay a fine of $5, which Justice Gorsuch recently pointed out, quite pointedly, is only about $140 today. Jacobson eventually appealed to the US Supreme Court. He relied on the prevailing standards at the time that were applicable to any civil liberties dispute, arguing that compulsory vaccination is unreasonable, arbitrary, and oppressive. He grounded his claim in the rights to due process and equal protection secured in the 14th Amendment. He did not raise religious liberty claims under the First Amendment, in part because at the time, the First Amendment was not understood to apply to the states at all. Jacobson is an iconic case, reconciling individual rights and the collective good, and also bureaucratic expertise with democratic accountability. It wasn't exclusively or even primarily a case about emergency powers, but in 2020, the Fifth Circuit interpreted Jacobson as an emergency powers case requiring suspension of ordinary standards of review during a public health emergency. In In re Abbott, the Fifth Circuit upheld a de facto ban on all abortions aimed at conserving healthcare capacity that was issued by governors in Texas and several other states in the early weeks of the COVID pandemic. Rather than applying Roe versus Wade, Planned Parenthood v. Casey, Whole Woman's Health v. Hellerstedt, the Fifth Circuit decided that the definitive standard of judicial review was set forth in Jacobson. The question was whether the order was arbitrary and unreasonable or a plain, palpable violation of the Constitution. The Fifth Circuit argued that if the Supreme Court in 1973 had meant for Roe v. Wade to apply even in a public health emergency, then it would have said so. It would have indicated that Roe was in some way an exception to Jacobson. This struck me as utterly ridiculous and dangerous. But I have a theory about why it was such an appealing line of argument for the courts. The coronavirus emergency orders raised a lot of novel questions about constitutional rights that were poorly developed prior to 2020. When my students asked me in March whether the government had the power to issue stay-at-home orders and travel restrictions and order business closures in the US, the answer had to be, we don't know. Probably, the courts would probably uphold reasonable restrictions, but there were open questions about who had authority to order restrictions, by what criteria, and for how long. The courts were reluctant to answer those questions amidst the uncertainty of the early months of the pandemic. In past public health emergencies, courts had relied heavily on guidelines from the World Health Organization, the CDC, and other scientific bodies to find that the government's actions are sufficiently grounded in science to satisfy a means and fit test. But throughout 2020, there were conflicting guidelines from CDC and the White House, which didn't give the same degree of cover that the states and the courts were looking for. The Fifth Circuit's interpretation of Jacobson as a suspension standard provided that cover. It provided a kind of rubber stamp of approval without requiring the courts to delve into these difficult issues in detail and provide new analysis that was not governed by pre-2020 precedents. So last summer, Steve Vladeck and I wrote an article arguing against the suspension interpretation of Jacobson. Some judges agreed with the Fifth Circuit, some judges sided with me and Steve and rejected it, and eventually, the night before Thanksgiving, the Supreme Court weighed in and altered the future of Jacobson v. Massachusetts, potentially for decades to come. In that decision, the new post-Barrett majority of the court put that circuit split to rest. The per curiam opinion for the majority in Roman Catholic Diocese of Brooklyn v. Cuomo didn't discuss Jacobson explicitly, but applied ordinary standards of review, arguably even beefed up standards of review to a First Amendment challenge to New York's restrictions on religious services. In their concurrences, Justice Gorsuch and Justice Kavanaugh discussed Jacobson at length. Justice Gorsuch in particular discussed compulsory vaccination in a way that I believe hints he sees himself as a potential swing vote in favor of upholding a vaccination mandate in a future case, assuming that mandate is tailored to his liking. Chief Justice Roberts also addressed Jacobson in his dissent, but only to clarify that when he cited Jacobson favorably a few months earlier, he wasn't endorsing the suspension, but was instead endorsing a far more anodyne and more flexible reading of Jacobson as holding that our Constitution principally entrusts the safety and health of the people to the politically accountable officials of the states. So what is Jacobson's enduring meaning after Roman Catholic Diocese? Will it survive the pandemic as a viable precedent for modern courts? Will it survive the Supreme Court's rejection of the Fifth Circuit's contortion of it into a suspension standard of review? All of that remains to be seen, but it's likely to become clearer in the coming months. If and when vaccination requirements for COVID are adopted, Jacobson will rear its head again. And even if that doesn't happen, ongoing challenges to routine childhood vaccination requirements for school attendance, for more routine threats like measles and pertussis are likely to raise the issue in the years to come, just as they did in the years leading up to the pandemic. But after Roman Catholic Diocese, it will no longer be tenable for the courts to respond to these challenges to vaccination requirements the way that they typically did in the decades before the pandemic. Cite Jacobson, cite another case from the 40s that endorsed school vaccination mandates, and say compulsory vaccination is fine. After Roman Catholic Diocese, especially after Gorsuch's extended discussion of what his reading of Jacobson would and would not permit in the way of compulsory vaccination, the lower courts will need to return to first principles. They'll need to thoroughly analyze, sorry, I got my warning and lost track of where I was. They'll need to thoroughly analyze how modern standards of review would apply to these claims. That's risky because the doctrinal questions raised by stay-at-home orders, the doctrinal questions raised by compulsory vaccination aren't well developed. And these two areas raise these questions about underdeveloped areas of the law for the same reason, because courts have been able to cite Jacobson as a kind of rubber stamp and leave it at that. But returning to first principles will also mean that the courts will have to play their constitutional role as a forum in which the government must justify its choices and present the evidence that supports them in ways that increase transparency and ultimately political accountability. Ultimately, I feel the bigger threat to achieving community immunity is anti-vaccination attitudes and concerns, not a lack of constitutional authority to mandate vaccination against people's will. That kind of public justification, including in the courts, may do more to win hearts and minds among the vaccine hesitant than a rubber stamp approach to government power. Jacobson is a powerful representation of what public health ethicist Dan Beecham has called the second language of American law and society. And I hope that this is the enduring meaning that persists after Roman Catholic Diocese's rejection of Jacobson as a suspension standard. Jacobson gives the courts the language they need for talking about how a society balances considerations of personal responsibility and social accountability in public policies that impact health. The idea that courts should suspend their application of ordinary balancing tests isn't what Jacobson was understood to stand for prior to the Fifth Circuit's abortion ban case. Jacobson's enduring lesson is that collective needs are a powerful counterweight to the values of classical liberalism that form the dominant language of American law, a language centered on the values of freedom, self-determination, self-discipline, personal responsibility, and limited government. The courts are going to continue to hash out the proper balance between individual rights and the common good. Jacobson's days as a rubber stamp may be over, but it still has so much to offer to modern courts grappling with these issues. Jacobson's enduring meaning is that common needs carry weight, that individual rights are not absolute. Jacobson also reflects a common sense approach to the structural constraints that have plagued coronavirus emergency cases in 2020. On the question of delegation, Jacobson recognized that authority to decide for everyone what must be done in an emergency has to be located somewhere, and it's within the constitutional authority of a legislature to delegate that authority to executive branch officials, particularly to health officials who are appointed in part due to their relevant expertise. In addition, Justice Roberts' reading of Jacobson is holding that our Constitution principally entrusts public health to the politically accountable officials of the states, offers an important caution to federal judges about their role in reviewing decisions by the political branches of state governments, which have primary authority and responsibility for protecting and promoting public health. I'll end on that note, but if you have further thoughts on the future of Jacobson, I would love to hear them. We don't have a ton of time for Q&A, but I'm easy to find on Twitter at Prof. L. Wiley or by email at wiley@american.edu. Thank you.
Wonderful. Thank you so much to all of our panelists for your insightful contributions today. Just two notes, I'd encourage everyone, if you have a question, please do use the Zoom Q&A function to submit it. We're monitoring that and we'll have a few queued up for the panelists in a moment. And the second note is that we had a couple of questions about the closed caption version of our panel today. It will be posted on the Petrie-Flom website as well as the Solomon Center website in a couple of weeks once we send it out to have it transcribed, and we'll get that posted. So come back to our websites to find that in just a couple of weeks. So before launching into the submitted Q&A, I wanted to ask each of you in sort of Petrie-Flom style, if you had to do a tweet today that would be what you hope the audience would take away from your talk, what would it be? And I guess we can start, we'll start in the middle of our lineup of panelists. Rakaya, would you like to start?
I knew I was going to be first. I would say that workplace spread needs to be addressed. That we cannot just rely on social distancing measures for the general public, that we actually need to do the best job that we can on contact tracing and stopping workplace spread.
Great. Nicole?
I think I would remind everyone that the choices we make for the long term affect short-term emergencies. And if we let it ride, that 12 states still haven't expanded Medicaid to the tune of millions of people being uninsured, if we let it ride that there are health and economic disparities that leave it so that we have the equivalent of third world nations within the United States, we are going to experience a much more severe disaster when the next one strikes. We cannot forget the lessons of this particular pandemic as quickly as we've forgotten the lessons of prior emergencies.
So I would say because individual rights protections have never been absolute, securing the common good does not require suspension of ordinary standards of judicial review.
And we started our paper, so I guess I would put it on the tweet with one of my favorite quotes from Joni Mitchell: "You don't know what you got till it's gone." That losing respect or trust in medical authority, in science, in truth itself, and that in the idea of facts has consequences that we only realize once we've lost it.
Thank you. And okay, so we do have a couple of questions in the queue. I think this one might particularly be well suited for you, Nicole. Where is the line between federalism as a policy choice versus a constitutional limit on federal powers? If a federal health law were to exercise something akin to the police power, wouldn't it be the latter? Isn't this why the president's executive orders on face covering specifically cover only federal property, federal personnel, and interstate/international travel?
So how much time do we have? The very short answer is that the federal government can do quite a lot as a constitutional matter these days. The commerce power and the spending power make it so that the federal government can exercise either directly or indirectly quite a lot of authority over health matters, whether they're individual or public health. That being said, there are certainly boundaries, and one obvious one is requiring the wearing of masks. It would be very difficult for the president to assert that he can require the wearing of masks within states where there is, for example, only intrastate activity. Now, could we argue that's a local activity with a substantial effect on interstate commerce, making it so that Congress should act and make it so that there's a nationwide mandate? Perhaps, but I do think that there are some spaces that are truly still local where it's very difficult to argue that you have federal power that can be exercised. Obviously, the president in an executive order can only do so much and needs to work with Congress on some of these questions. And of course, budget reconciliation can only get you so far because those are monetary matters, not substantive matters, at least procedurally speaking.
I'd like to jump in on this one too and just say that my answer to this question about a national mask mandate has really evolved as we've gotten decisions from the federal courts upholding the federal eviction moratorium. And I was somewhat surprised by the sweeping reading of both constitutional authority in terms of interstate commerce power and in terms of the statutory authority available to the CDC director and the president under the Public Health Services Act to issue these kind of orders targeting intrastate activity that contributes to interstate spread of disease. And so I think in the coming years, we're really going to need to see some rulemaking out of CDC to articulate the boundaries on that broad interpretation of its statutory authority and provide some statutory guardrails to ensure that that authority is exercised well. It also relates back, though, to the policy question, which is the federal government, regardless of whether it has authority to issue something with order at the top of it that says wear masks everywhere in the US, does not have the kinds of enforcement mechanisms that are available to state and local governments. And so it may be permissible under these two new federal court precedents to issue a nationwide universal mask mandate, but I continue to believe it would not be wise to do so.
I would also
can I jump in there? Oh, go ahead. Go ahead,
I was just going to say that there's also a temporal concern there, right? That you reach a point at which an emergency is just the norm because it's been going on for so long that it's no longer emergency powers, right? And then it's just an excuse to do what you see fit. So I think that we have to be cautious too about about the duration of these kinds of maneuvers.
And I was going to jump in, but it's a little different in terms of workplace. We already have the powers in place. We have OSHA, we have USDA that have powers to actually go in and inspect and contact trace, but they are not using their powers to do it. And so are there ways that we can shift or partner with the CDC to actually be able to do that? Because as many of the outbreaks are happening in meat and poultry processing plants, that's who they called in, the CDC. And we already have a system where in some states, they are actually doing these federal inspections. And so I think it's a great place to test this federalism where you already have a system in place where the federal government is working with states to implement and protect workers.
Yeah, and I think that's a really important point that Professor Yerby made about OSHA being another location for federal action on masks. To Nicole's point about emergency declarations, one thing that's really important to note is that the 361, the Section 361 authority that the eviction mandate eviction moratorium relies on, and that the mask orders rely on as well, is not contingent on a public health emergency declaration. It's sort of background authority that just is floating out there, which is all the more reason that CDC rulemaking is needed to tether that authority in some important ways. Alternatively, Congress could step in, but that's always less likely than administrative action. One possibility is that CDC rulemaking could create a crosswalk to the public health emergency declaration that's not there in the statute itself.
Great. Well, I am mindful of our time together being up. We're wrapping up at 1:15 today, and it's now 1:16. So in this virtual world, I wish that we could embrace our panelists with a warm round of applause. So I guess virtually, we are all grateful for your contributions, and we're really looking forward to seeing this work come together in our publication format moving forward. So thank you so much to all of you for your contributions, and we look forward to seeing you at our next panel discussion.